Oh, look at you. Look at you.
I can walk.
Step.
I can actually walk.
That's kind of amazing.
I think it just needs to. Nice to see you. And while I'm here, I'll just say, I wore those shoes yesterday. I just bought them because my friend found them.
Really? Yeah.
They're so comfortable.
And
I
I
live
wore
on the
them all week. I did my first time I did was
Yes.
trainers training.
Yes.
4 day at Precious Blood.
4 full
I
days.
worked
I'll
out
get there
the-
late
my
Tuesday
favorite
night
thing I
and
did
have
was
to
like
like practice all the
position.
I'm doing a lot of it.
Yeah.
No, I love them.
They're the best, and what the best thing is if you go like this.
I'll flash the rainbow
Yeah,
at you.
exactly.
I feel like that was tempting fate.
Did you see Representative Cassidy's shirt? Those look familiar?
Yes.
I didn't wear them today because I was like, I have to wear my
That's sweet.
my black pants shoes.
All right, I think we can go ahead and get started. First of all, I'm Kathy Solmarsh. For those of you who are not familiar with SPAC or have never been to the Resentencing Task Force before, I'm the Executive Director of the Sentencing Policy Advisory Council, which provides administrative support with the help of a magnificent planning team for the Resentencing Task Force. So I'm just gonna give you a few little housekeeping items, take roll, and then we're gonna get underway. First of all, for those in the room, bathrooms are behind that wall, as are drinking fountains where you can get access to water. Please don't spill your coffee, we're technically not supposed to have it on the carpet, but come on, we need our coffee. Just wanted to let you all know that we do have a Resentencing Task Force mailbox, spac.rtf@illinois.gov, which we will be publishing and sending out to our distribution list. I'll send an email to all of you, or Mike Elliott will be sending you an email, so you can then blast it out to anybody you want to blast it out to, and we can start getting some interaction with people who are interested in having input. I am thrilled because at our last meeting, we all voted to not proceed until we had full appointments, and by golly, we've got them. Yes.
He's doing it, well done.
We have our 3 retired judges, Cheryl Ingram, who is the unique judge who was a public defender before she got on the bench, and Steve Sawyer, who is on with us via WebEx, who is like myself, a downstate guy. And Steve, I couldn't even begin to recite the number of counties in the circuit you sat on, but suffice it to say, there were like 12, I think, in his circuit. And then sadly, our third one, Mark Salone, cannot join us today due to some previously planned international travel. Poor guy.
Right.
But I am really happy to report that he has agreed to act as our chair. So he will be joining our planning team calls, and he will be with us when we next meet. And then finally, we have Lisa Daniels, who represents victims of violent crime. It's unfortunate that she has that ability as she lost her son to gun violence. Lisa is also a member of the Prisoner Review Board and SPAC, so she has a lot of interconnections. But with these members, we have a full contingency, and that is a good thing. So with all of that, I'm going to take the roll for purposes of establishing quorum. Kelly Cassidy.
Present.
Ryan Spain. Representative Spain, I
present.
think. Oh, there you are,
Thank
okay.
you.
Robert Peters.
Here.
Darren Bailey. Or Colin, if you're here for Representative Bailey. Bob Berlin.
I'm here on Zoom.
Scott May.
Here.
Ari Jones.
Here.
Sharon Mitchell was gonna send a designee, but I don't think we have that person yet. Latoya Hughes.
Present.
Lisa Daniels.
Here.
Joby Cates.
I'm here.
Yakov Delaney.
Present.
I think I saw you. There we go. Chief Davis can't join us today. He is ending his tenure as the president of the Chiefs of Police Association at their annual conference. Shobha Mahadev.
Here.
Cheryl Ingram.
Here.
And Steve Sawyer.
Here.
All right, that is fabulous. Thank you all. All right, I'm gonna have actually one more housekeeping item before we get into approving the minutes. Those of you who are calling into the WebEx, if you have a question or a comment that you would like to share, you can do that by emailing it to john.specker@illinois.gov, and we will read those questions and comments. And those of you who are on WebEx, members and presenters, obviously unmute yourselves to participate in any questions or comments. All right, with that, I will ask you all to comment if you have any comments, corrections, additions on the minutes that were provided in the meeting materials from our first meeting. All right, I see no hands up and nobody's commenting. So could I have a motion to approve the minutes?
So moved.
And I need a second.
Second.
All right. All, those legislators, you know,
Process.
I don't care what they say,
Get
the
the
two
process
chambers
down.
can work together as just Since we are live and in person, those in the room, I will ask all in favor, say aye.
Aye.
Any nays or abstentions? All right, for those who are on Zoom, I gotta call your names. So Bob Berlin,
Yes.
Steve Sawyer,
Yes.
Ryan Spain,
Aye.
Latoya Hughes,
Aye.
Yakov Delaney.
Aye.
All right, with that, the minutes are unanimously approved. Thank you all. And I will now hand it over to our moderator, Susan Lloyd.
Good morning, everyone. I want to reference some of the people in the room. Kathy mentioned that there's a planning team that's been working behind the scenes to put together materials and agendas for your meetings. Bill Neeson, Lisa Schneider, Babes, Kathy, Lindsay Hammond, and who am I leaving out? Mark Elliott.
Mark and Mike.
Mark and Mike, so from SPAC. So this group really felt it was important to do some sort of level setting for the entire task force membership and put together some panels of experts to provide information to inform the discussions. I want to take a minute and walk through today's agenda and then spend a minute or two looking at the schedule for the rest of the project. It has changed, so I wanted to make sure that we went through it and people were aware of the schedule changes. Anyway, today's meeting is the first of 3 expert panels. Today we're going to hear from a group of individuals who are experts on resentencing. In a second panel, we'll be looking at issues of behavioral health in relation to sentence review. And then a third panel will be a panel of professionals in corrections, commenting on what they imagine resentencing would do to their internal processes. Those are to inform meetings that we'll have about eligibility, qualification, meetings about legal and procedural issues related to resentencing. In June, let me back up. By the end of the summer, we will have had those 3 panels and meetings about eligibility and legal procedure. Following that, this group would put together a set of recommendations. We will circulate those recommendations for revision, and they would be a part key part of the final report. And then by the time December rolls around, we will have completed the recommendations, we will have drafted a report, you will have had the opportunity to preview that material, revise it, fight about it, affirm it. So the schedule is in your packet. And the main thing I want to say about the schedule is that we have meetings every month except for May. You may have May on your calendar, May 20th on your calendar from a prior scheduling discussion. That meeting is being canceled because Catherine has a prior commitment to getting a hip replaced.
Getting a new hip, people, we'll be able to kick ass even better.
So now on to today's panel and discussion. I'm going to turn this over to Bill.
Can I ask one quick question? Is there timing, has timing been announced for
I'm
these
sorry.
meetings? For these meetings that are the schedule, are these at 9 a.m. meetings or these later in the day meetings? Do we have a sense?
I think we will keep it at 9 unless somebody,
Does it work for you?
I would only say there may be 1 or 2 meetings where we're gonna have more time, as we did in our first meeting, but right now, we're thinking 9 to 11 will be the standard, and hopefully everyone will be able to be in the room.
Okay.
Thank you.
Any other questions on the schedule? Hearing none, I'm going to turn this over to Bill.
Okay, thank you, Susan. The title of our panel this morning is Rationale for Resentencing and Research Supporting It. And we've got 3 people with a great deal of expertise in that area. And I appreciate very much their willingness to come and meet with us today. I'll introduce them briefly, and then we'll go into, each one will give about a 10-minute statement, summarizing points they would like to make, and then we'll go into discussion after that. So our first panelist will be Dr. Nazgul Gandanush, PhD. She is a senior research analyst at the Sentencing Project, which is a nonprofit organization in the District of Columbia. And she conducts research on criminal justice policies, focuses on racial disparities in the justice system, public opinion about punishment, and the scope of reform efforts. She has written a report which was provided to all of you ahead of time, called A Second Look at Injustice, which is really an in-depth look at resentencing, which is often referred to as second look sentencing as well. Our second panelist will be Jane Ann Murray, who is a law professor at the University of Minnesota Law School, where she runs a clemency clinic that she founded in 2014. And she's also been a public defender in her prior life before that. And finally, the third panelist will be James Ziegler, who's the founder and executive director of the Second Look Project, which is located in the District of Columbia. And James, the District of Columbia has a resentencing law in effect right now that's fairly new. I think it's been in effect for about a year now. And James has a great deal of experience dealing with that law. And his nonprofit organization provides legal support to people seeking resentencing under the DC law. So thanks to all the panelists, and we'll start off with Nazgul. If you could start off with your statement, please.
Thanks so much, Bill. Hi, everyone. So I'm going to share some slides with you, and I'm also going to reference a couple of links that I'm going to put in the chat that you can just have for your reference to look at later. So let me get my slides started here. All right. So I want to start by just noting the significance of the work that you're doing. So this is a chart that shows the growth of the US prison population, and you can see that it's a really dramatic growth. Starting point here in this chart is 1980, but we know it began in the 1970s. And there's been a relatively modest decline in the total prison population. But what this chart does is it breaks down the prison population based on offense type. And you can see that the line at the top is, so that's the largest population, that's the people who've committed violent crimes. And then below that are lines for people with drug convictions and property convictions as their most serious offenses. So most of the progress that we've had so far in reducing the prison population has been around the population whose lines are at the bottom there, people with non-violent convictions. People who have violent convictions, we've barely budged the population size there. And I understand that you have had a chance to look at some of these data specifically for Illinois. But what I want to point out here for you to see is that the dramatic size of growth that we've had with the population imprisoned with violent convictions, and that's dramatically after reaching a peak in the 1990s. Up until the point that this graph ends, 2019, violent crime rates fell by 50% in the United States. We have an uptick now that we're trying to figure out how to respond to. But during this period at which violent crime rates went down, we continue to increase the prison population who is there for a violent conviction. And that's really anomalous if you look globally. If you compare the United States to 24 other countries that experienced an uptick and then a downturn in violent crime rates, we're the only ones that responded by dramatically increasing incarceration levels while crime rates were going up. And we kept doing it even while crime rates were going down. And so your work focusing on resentencing, and in particular figuring out resentencing for serious and violent crimes, is critical to bringing down the number of people in prison. And that's because the size of the prison population for any offense it has to do with the number of people going in, but also very importantly, how much time they spend in prison. And we know that there's been a dramatic growth in sentence lengths across the board, but in particular for violent crimes. So we at the Sentencing Project have estimated that 1 in 9 people in US prisons is serving a life sentence. In Illinois, our estimate is that that's roughly 11%. That includes 1,600 people serving LWOP and another 2,700 people serving what we consider to be virtual life sentences of 50 years or longer. So before I talk to you about the criminological foundation for why these sentences are problematic, ineffective, and even counterproductive, I want to just give you this short highlight here. This is a quote from University of Miami criminologist Alex Picaro, and he and his colleagues looked at research on criminal careers and found that they typically last shorter than 10 years. And as they note, this calls into question the very long sentences that characterizes American penal policy. And I'll get more into this soon as well. But first, I want to give you a sense of some of the reform efforts that we've been seeing around the country that's become more responsive to this evidence. And I would say that a major turning point was the introduction of the federal second look bill by Representative Karen Bass and Senator Cory Booker. This is a bill that was introduced in 2019, and it would allow people who have spent 10 years in federal prisons to petition judges for resentencing. And it included a rebuttable presumption of resentencing for people aged 50 and above. This bill has inspired model state legislation proposed by the National Association of Criminal Defense Lawyers, which Jane Ann will speak to you more about later. It's also helped to support the advancement of reform efforts and implement reforms around the country in places including Washington, D.C., and James will talk to you more about that. And our report also describes some other reforms, so the ongoing effort to pass an elder parole bill in New York and the implemented second look bill in California, which is a prosecutor-initiated resentencing law. So the first link that I shared with you in the chat includes a list of second look bills around the country that an organization named FAM has put together in case you want to get a sense of the breadth of these reform efforts. So who supports these reforms? So a number of legal experts, for example, over 60 reform-minded prosecutors and law enforcement leaders who signed on to this joint statement by the organization Fair and Just Prosecution. And I include that as one of the links that I've shared with you. It's the second one if you want to read the full statement. And what they say is that they call for legislators to create laws that enable them to initiate second look resentencing efforts. And so a number of the prosecutors who signed on to this, who have this authority, have implemented sentence review units to take a look and reconsider sentences in the interest of justice. These are different from innocence units that look at the question of innocence. This is for people who are guilty and examining what length of sentence is appropriate given their guilt. Other legal experts that support this include members of the American Law Institute, who have established the Model Penal Code. This is a template that is provided to states that they can rely on to develop their own criminal laws. And this is the recommendation from the Model Penal Code that sentence modifications be permitted after 10 years of incarceration for youth convictions and after 15 years for all adult convictions. A similar resolution is being considered by the American Bar Association as well. And I want you to note here that the author, one of the lead authors of the Model Penal Code, Kevin Reitz, a University of Minnesota law professor, along with national parole experts, Edward Ryan and the late Joan Petersilia, they have recommended that resentencing begin after 10 years of incarceration themselves. So why is it that the American Law Institute recommends this? Well, briefly, it has to do with the fact that sentences that were imposed a long time ago, decades ago, do not reflect our evolving norms and our evolving knowledge base. And that's why it's important to be able to have a chance to reconsider these very old sentences. So let me tell you about that knowledge base and the criminological foundation for resentencing. So we know from an abundance of research that people age out of crime and that recidivism declines with age. So the chart that I have on the bottom left here is a classic age crime curve showing the prevalence of arrests at different age levels. And this is an age crime curve for murder. And you can see that people who are in their late teens and early 20s are at the highest rate of likelihood of being arrested for murder. And then the rate of arrest declines with age and then gets really very low once people reach their 40s. And this is something you can also see in recidivism studies of people who have served decades in prison for the most serious crimes are the least likely to recidivate. And you can see this, for example, illustrated in the picture that I have on the right here. This is a group of people known as the Ungers who were released from Maryland prisons because of the Unger versus Maryland court case that found problems with their jury instructions. If it were not for that case, they would most likely still be behind bars. Extremely low recidivism rate among this population, as you would expect from looking at them. This is an elderly population that's very unlikely to criminally offend. Now you might think, never mind the people who have committed crimes. Aren't we sending a strong message to deter others from committing crimes by maintaining very long sentences? And the answer there, again, from criminologists is a very clear no. Daniel Nagin, one of the most notable criminologists in our country, has looked at this question extensively and said that very long prison sentences beyond 20 years, for example, do not have material deterrent effects on crime. Why would that be? For a number of reasons. First, people don't expect to be caught. And that's not an unreasonable expectation, even for the most serious crimes when you look at our clearance rates. Second, people commit crimes under the influence of drugs and alcohol. That impairs their ability to think rationally, and they may not be familiar with the sentences that they face. So that's why the deterrence argument also fails to support maintaining very long sentences. And then finally, these long sentences divert resources from making more that we could use to make more effective investments in public safety. The third link that I sent to you is a list of the kinds of programs we should be investing in more heavily. And the fourth link is a report by For the People in California that look at prosecutor-initiated resentencing. They helped to pass the law that's in place in California. And these are their estimates of savings if that law were more fully implemented in order to resentence people and bring about more releases in that state. So 2 final points I want to end with. One is about victims. We should certainly keep victims at the forefront of our minds and our discussions and planning here when we think about resentencing and think about how can we help prepare victims for this process. But it's important to note, I will finish in 30 seconds here. I heard that beep. Victims are not monolithic. There's a variety of perspectives. Here's an example of an organization, Network for Victim Recovery of DC, that has supported the resentencing reforms here and calls for tackling the root causes of crime to prevent others from experiencing the kinds of trauma and suffering that they've been dealing with as survivors of crime. Finally, a point about racial equity. Many of the people that are incarcerated right now with extreme sentences were sentenced at the super predator era. This was a time of a mythic crime wave and hysteria in response to that, and in particular directed at young Black men. And so we really need to realize that we're in a different place now, but we still have lingering racial biases that prevent us from seeing the full humanity of the primarily Black population serving these extreme sentences, and to recognize that most of the people that are victims of serious violent crime are communities of color who call for something more than just very long penalties, who are calling for policies that get to the root causes of crime. And I'll stop there. Thank you.
Thank you very much, Nazgul. Appreciate what you've provided us, and we'll have a chance to ask Nazgul questions later on. So now we'd like to go to Jane Ann Murray. Could you make your remarks now, Jane Ann? Appreciate that.
Actually, I did not realize that I can't share on WebEx right now. I am more.
Give us a minute, Jane Ann. We'll make you a co-host, and then you'll be able to share.
Yes, but it's asking me to open system preferences to permit access, and I'm trying to do that, but it's not offering me that opportunity.
All right, Jane Ann, you may have to log out and log back in. Do you want me to show your slides for you? Would that be helpful?
Yes, that would be awesome. Thank you very much, Nazgul. That's great. I'm so glad I emailed them to you.
There we go.
Excellent. Thank you so much. So, hello, I'm Jane Ann Murray, and I am also on the board of the National Association of Criminal Defense Lawyers, where I co-headed its task force on our model second look legislation, which essentially took up the cudgel from the ALI and its model penal code that was reissued in December 2018, and which included a second look provision that would encourage states to pass legislation permitting a second look after 15 years for everyone and after 10 years for juveniles, but did not actually draft the model legislation. So we took up that cudgel and did that ourselves. And if you go to the next slide, Nazgul.
Mm-hmm.
So these were the components of our legislation, which was also looked to the federal bill drafted by Booker Bass that Nazgul mentioned. So we propose a second look after 10 years for everyone, a review, a review no more than 5-year intervals thereafter, harnesses the Department of Correction to commence the process and identify eligible inmates, meaning individuals who had served 10 years. The petitioner, the prisoner, has the right to appointed counsel, requires a face-to-face hearing. We can go into that later. very much at least, even if it's remote, that there will be the sentencing judge will look at the individual involved, sets forth the factors to be considered, addresses victim participation, appellate review, and fundamentally animated by principles of humility, meaning we may have got it wrong in the past, and humanity, addressing the individuality of each prisoner. Next slide, thank you. I'm going to focus in this talk on 4 of these provisions, and I thought that the best way to do so would be to focus on, give you just 4 examples of cases out of my own project from the University of Minnesota Law School, and then talk about why those cases illustrate for us the reasons, the choices we made in the provisions that we placed in our bill. First of all, the issue of why petitioner driven? So this is Darren Perkins, a client of mine who was charged in 1991 at the age of 26, both at the state and the federal level for his role in a street crack conspiracy. His role was nonviolent, unarmed, and he was in fact arrested with 16 grams of crack. He was offered 5 years pre-trial, but he elected to go to trial and ended up being convicted and was sentenced to life in prison without the possibility of parole under then existing federal sentencing guidelines. In 2017, on a petition that I had written, his clemency was denied by President Obama, which meant that it had gone through several reviews at the Department of Justice. The sentencing judge had written in support of clemency, so more than likely this was denied because of opposition internally from prosecutors. We don't know, the process is not transparent. Ultimately, we went back to court after the denial and did petitions both at the federal and the state level. And after 3 post-conviction petitions, which of course were filed by Mr. Perkins, by me, we ultimately were able to secure his release. Next slide, please. And so we proposed petitioner-driven simply because the traditional gatekeepers that people would rely on, prisons or prosecutors, are simply not going to file the number of petitions that a second look process would permit. It's really well illustrated in the compassionate release, the so-called compassionate release provision of the First Step Act, again passed in 2018. This prior to this, at the federal level, only compassionate release motions could be filed by the director of the Bureau of Prisons. And the history of that was that, frankly, a handful of these would be filed every year. Very few people were being released under the compassionate release provision at the federal level, and often they died prior to the process being completed and prior to release. But the First Step Act permitted individuals, the individual prisoners, to petition the court for compassionate release. So it completely galvanized and changed the process. There was a small exhaustion of remedies issue that had to be addressed, but otherwise the prisoner could go directly into court. And with COVID-19, we saw thousands of petitions being filed by individual prisoners across the country, many of them counseled. This is a report from the Sentencing Commission looking at the first year of the COVID-19 pandemic and the use of the compassionate release statute to release individuals. As I say, prior to the First Step Act, maybe 30 motions a year. In financial year 2020, there were 7,000 petitions, and the judges granted 25% of them. About 1,800 people were released in financial year 2020. Next slide, please. Why we specifically ask that there be representation of the individual petitioner. Why representation? This is Zoanne Brown, mother of five, who pled to participation in a federal drug conspiracy in her mid-30s, having developed a meth addiction. She was sentenced to 24 years in prison by her federal judge in 2007. Her pro se clemency petition to President Obama was denied in 2015. I met her shortly after that denial. We then submitted a counseled clemency petition. This was granted a year later. In the process, we had reached out to our sentencing judge and asked him to review the petition and asked him to write in support. He wrote an amazing letter where he said, "My sentence was too long by a country mile." A very crystal clear presentation of why representation is so important. Next slide, please. Counsel are frankly the most effective. They know how to cut through extraneous details, investigate, uncover new facts, make new legal arguments that the individual prisoners really wouldn't have thought of or aren't capable of making. Keep in mind, there's a lot of mental illness and intellectual disabilities in prison, so it's very hard for prisoners to file these pro se. It's also hard simply to advocate for yourself from inside and get access to the tools and the information and the records that make the clemency petition or the second look petition effective. We can go into this in the Q&A, but there are many recent analogs showing at the federal level in particular that large-scale representation is viable. Next slide, please. Now, why do we want this to be a judicial procedure, and relatedly, why the original sentencing judge, if available? Illustrated in the case of Rihanna Paxton, a mother of 5 charged in a federal drug conspiracy, nonviolent, low-level, unarmed career, offered pre-trial a real Hobson's choice: take a 21 to 27 year sentence with no possibility of departure. The judge's hands will be tied, or go to trial and you will face a mandatory life sentence. She had no choice but to accept the plea, and the judge had no choice but to impose 21 years. The judge, however, said at sentencing he would have given no more than 10 years and wrote a very compelling letter in support of her clemency petition, and ultimately her clemency was also granted after having served about 10 years in prison. Next slide, please. And so why do we say the sentencing judge? Well, and why in court? Because sentencing is traditionally a judicial function. Judges are really in the best situated to conduct an individualized assessment. They have the resources, they have backup, this is their expertise. The original sentencing judge is actually the most immersed in the case and most familiar with the individual. It's a public process, it's transparent, it's subject to adversarial testing, and of course subject to appellate review, all of which addresses the potential for arbitrary decision-making. Judges are insulated in part from political pressures. In many states, judges are appointed. I'm actually not familiar with the Illinois situation, but even judges who are elected tend to get very long terms, and so there's a certain insulation that prosecutors and governors don't, and parole authorities are not so insulated from. And of course, it performs an educative function to have the judges go back and see the struggles of prison, the capacity for redemption, to go back and see perhaps that their sentence was too severe, and it's something that may inform their sentencing. Next slide, please. And I know that I'm very close to the end here. Why no categorical exclusions? So this is definitely going to be something that I'm sure in your task force you talk about. Let's exclude the violence. Let's exclude people who are convicted of homicide. Let's exclude the sex offenders. This is Samantha Hygis. She was convicted after trial in 2008 of second-degree murder. She had drowned her newborn in the bathtub at age 19. She had been in a very abusive relationship with somebody who had isolated her from everyone. She had not gone to a medical professional. Her family did not know about her pregnancy. She was sentenced. She went to trial, rejecting an offer of 4 years, and she was sentenced to a guideline sentence of 25 years. I met her after she'd served about 12 years. We filed her clemency petition, and this past December, the Minnesota Board of Pardons, which requires a unanimous vote from the chief judge, the governor, and the attorney general, voted for the first time in a 3-person unanimous vote in 30 years to grant clemency to somebody who was convicted of homicide. And it was supported by her judge. Now, when you think about the nature of this offense, there couldn't be a more vulnerable victim. There couldn't be a more tragic, horrific case. At the same time, it's one that called out for clemency and mercy, and the sentencing judge and the 3 panel members of the Minnesota Board of Pardons supported it. Last slide, please. So just finally, why no categorical exclusions? I'm giving you here the whole pie, which is a totally fascinating project done by the Prison Policy Initiative. And they're showing you visually who is in custody. And if you look at the green section there, state prisons, 1 million individuals in custody, and you look at how many are in on violent cases, you realize that over 60% of people in state custody are in on violent cases. So when we start doing categorical exclusions, especially person offenses or homicides, we're excluding a huge swath of the individuals who are incarcerated. And if we want to make a dent on the issue of mass incarceration through a resentencing process, we do have to embrace the reality that we will have to do so in cases involving violence. Certainly, the nature of the offense can be considered in the resentencing process, and it can be the reason why the person doesn't get a resentencing. And the nature of the offense can also be a factor in deciding the level of process that can be given in the case, that it doesn't have to be a full-blown hearing. It can be one that's just one where the court puts it on the calendar for a relatively short status conference. It doesn't require bringing victims in and re-traumatizing them. But a categorical exclusion, I think, is fundamentally inconsistent with the humanity principles underlying this whole concept of a second look. And it potentially excludes extremely deserving individuals like Ms. Hygis that we saw on the previous slide. Thank you very much.
Thank you, Jane Ann. Now we'd like to go to James Ziegler, and he will tell us about the actual resentencing law that is in effect in the District of Columbia and what his experience has been with that. So please go ahead, James.
Thanks. So my name is James Ziegler. I am the Executive Director of the Second Look Project here in DC. We are an organization that was developed really in response to DC's passage of its Second Look sentencing mechanism. And we have been in operation since about 2020. DC's Second Look mechanism, though it has changed over this time, has been in effect since 2017. So we're coming up on about 5 years of having our law in effect, and I think it really are at a point where we're able to kind of look, at in a meaningful way, or for meaningful results from the 5 years that we've seen. So I am going to share my slide. I think it's going to let me. And there's a firm's logo at the bottom left, so I apologize for that. These are slides that we use for a presentation to one of our law firm partners, but rather than reinventing the wheel, I use some of these same slides. So anyway, our law is titled the Incarceration Reduction Amendment Act. It was passed in 2016 as a part of a broader package of juvenile justice reforms, and in its current iteration, the way the law operates is that anyone who is serving a sentence for an offense committed before they turn 25 and who has been in prison for at least 15 years can file a petition with the trial court for a sentence reduction. When the law was passed in 2016, the law only applied to people who were under 18 at the time of the offense, and it was really passed as in an effort to kind of codify and carry out some of the principles expressed in a line of Supreme Court cases.
Yeah, James, could you hold up just a second?
Sure. Sure.
Hold up just a second. The task force would like that slide to be blown up some more, if it could be.
Yeah, we can't see.
You
need
put
to
it
be
on,
full
it's
screen.
on your viewing mode, not the present mode. So it's showing us the current slide and your next slide.
Yeah, I think you need to put on.
Yeah, there.
Let's see.
There we go. Well done.
There we go.
Is that better?
Okay.
Yes.
Thank you.
Oh, great. The current, or the law was originally passed as a kind of way to codify some of the principles articulated in a line of Supreme Court cases that culminated with Miller versus Alabama and Graham versus Louisiana. There have been some since then, but those were kind of the last two kind of really substantive ones that established that mandatory life without parole sentences for people who were juvenile at the time of the offense were unconstitutional, and then Graham made those retroactive. And so I just have to see if I can. There we go. Does that work?
Yep.
And so we won't spend too much time on these, but these are kind of the seminal cases in the line of Supreme Court cases dealing with the most serious punishments and how we impose them on people who were children at the time of the offense. And excuse me, the way our law works, and again, it presently applies to people who were under 25 at the time of the offense. And I'll speak. Well, before we get into that, I will backtrack a little bit. So as I mentioned, our law was originally passed in 2016 and created a relief mechanism for people who are under 18 at the time of the offense. And this made about 100 people eligible, give or take. And it went into effect in 2017, and that is when these cases began to be litigated in our trial court, DC Superior Court. And it was about another year until cases actually saw resolutions and we saw people begin to come home. And the cohort of people who were kind of among those first cases heard and the first people released were really such strong embodiments of the principles that we kind of think of when we talk about these second look mechanisms, who just people who had very clearly demonstrated their rehabilitation and maturity and growth and were so clearly not the people they were when they committed these offenses as young people, that they generated really a great deal of community support for the bill, and both within our local legislature and within the community, and I think really kind of convinced people that giving people a chance to come back in front of the court and show that they're not the same person they used to be and are ready to come home is a really worthwhile endeavor. And so in 2019, our legislature introduced a bill that would expand that to people who were under 25 at the time of the offense, with the reasoning behind that being that the kind of developmental maturity piece and the idea that young people are kind of less developmentally mature and therefore less culpable for offenses and more capable of rehabilitation and reform. The science showed pretty clearly that developmental maturity is not actually reached in terms of executive functioning and these sorts of things until the mid-20s. And so that was the basis for the decision to expand the eligibility range to include young adults, or what we've kind of come to describe as emerging adults, people who are in that kind of phase of life between adolescence and actually kind of like fully matured adulthood. And so that passed last year, making several hundred additional people eligible, and that's where we are today, that people who are under 25 at the time of the offense are now eligible. The statute sets out two threshold findings that the court has to make in order to reduce a sentence. The first is that the petitioner is not a danger to the safety of any person or the community, and the second is that the interests of justice warrant a sentence reduction. And it sets out 11 specific enumerated factors that the court is to consider in making these findings. And in bringing these cases, the petitioner has the burden of making these showings that they are rehabilitated and not dangerous and deserving of a second chance. And so we'll talk a little bit more about kind of what the statute looks like in just a second, but I think the really important thing about the way this works is that it's not a free pass for anybody. The judges are really doing a thoughtful and lengthy consideration of people's histories and records and trajectory to determine if this is someone who can safely be released, and someone who's kind of earned that opportunity. And the focus really has been on dangerousness. As anyone can understand, the last thing a judge wants to do is release somebody who's going to go out and commit another offense of any kind, certainly another violent offense. But so judges have taken that responsibility very seriously, and it does not function as a kind of rubber stamp in any way. It really, petitioners have a meaningful burden to meet, and it's a big undertaking to make that burden sometimes, or to meet that burden. And so the factors that the statute requires the court to consider are derived largely from that line of Supreme Court cases, but really amount to a pretty holistic review of a petitioner's life from the top, basically from birth to the time of the offense in the case, to kind of explore or establish any kind of mitigating history or kind of context that might explain, how a young person came to commit such a serious offense. Because of the time served requirement, our law deals pretty much exclusively with people who have committed violent offenses. And then from the time of the offense to the present, to review the person's institutional history, track record of growth and maturity and rehabilitation, and really allow the court to decide, is this someone who's changed, and is this someone who presently, we feel good about and who can safely be released. And so the slides are up here. I won't go into too much detail, but factor number 3 is the institutional history, so disciplinary history and programming. This has been one of the most important things to our judges, to basically see, our judges have by and large accepted the proposition that people who commit serious offenses when they're young can and often do, grow and rehabilitate themselves. But they want to see evidence of that. And what they've looked to more than anything else is kind of what that person has done during the time they've been incarcerated. And so that includes the positive things, the programs they've completed, if they've done college classes, if they've done kind of behavioral therapy, if they've done, mentoring programs, in addition to disciplinary histories. Is this someone who has, conducted themselves in a way while incarcerated that makes us think that they're going to, continue to follow the rules and do what we want them to do when they're released. And so that the institutional history has been really a primary focus of judges. The statute does require the court to consider any statements by the victims or victims' family members, and under our separate Victims' Rights Act, they have a right to submit a statement and be present at any motions hearing or resentencing hearing in these cases. And though they are not always present, oftentimes, or at least sometimes, because of the age of these cases, people are unable to find the victims or their family members. More often than not, they are involved. And as I think Nazgul noted, the reaction of victims and victims' rights organizations is not a monolithic one. Certainly, you have a decent number of people who are opposed to relief and come to court and say that, but you also have a significant number of people who are appreciative of the fact that people can change, and if they have seen a demonstrated change in that person, are willing to say, well, we think the time they've done is enough, and they're ready for another chance. Any reports of physical or psychiatric examinations? Occasionally, lawyers will have psychological evaluations prepared for their clients. They're going to provide a clinical perspective on the client's rehabilitation and present level of risk. We don't do that in every case. It's not required, and oftentimes it's not necessary, but we do it sometimes. The defendant's role of the offense and the involvement of co-defendants or other people. Factor 10 is a kind of categorical recognition of the mitigating factors of youth that kind of underlie this law and that line of Supreme Court cases. And 11 is kind of a catch-all that allows the court to consider anything else that it deems relevant. But the specific enumerated factors have really been what judges have kind of placed their primary focus on. the way it works is that.
James, we're getting to the end of your time, so if you could wrap it up.
Sure. I've got just one more slide, I think.
Okay, great.
This is a very brief overview. A petitioner files a motion for a sentence reduction. These are usually lengthy briefs that include several hundred pages of exhibits documenting their institutional record, childhood history, things like that. The government has a chance to respond. In our case, the government has usually opposed these motions, but not always. And in other jurisdictions that have done similar things, prosecutors' offices have been a little bit more supportive of these efforts. The defense gets the petitioner gets a chance to respond to whatever the government says. Then the court holds an evidentiary hearing at which the petitioner can speak. The lawyers can ask questions. Everyone is entitled to counsel as a function of the way things work in DC Superior Court. And so to Jane Ann's point, it's extremely important that people have counsel in these cases. And then the court has to issue a written opinion outlining its reasons for either granting or denying the motion for a sentence reduction. And then the petitioner has a right to take that to the Court of Appeals if they think the trial court did something wrong. And then if denied, they have a chance to reapply for a sentence reduction in 3 years. So far, we've had nearly 100 cases that have been resolved under our law. And of those, about 80, maybe a little bit more than 80 people have been granted relief and released. We've had less than 5, I think the number is probably 3 people rearrested for any offense of any kind. And as mentioned before, as it relates to kind of why they chose to expand the law, there has really been overwhelming community support for this mechanism, for the people who have been made eligible under it. And we've seen, by and large, that the people who've come home have really done a great job of re-entering and taking their kind of second chance seriously, and are, in almost every case, functioning, productive, contributing members of our community. And we're real happy to see how that has turned out. And that's
James,
it.
can I ask you 2 mechanical questions before we end?
Sure.
First of all, how does your organization get involved in a case? And like, what's an average timeline for how long it takes to get from start to finish?
1 second. I'm trying to expand this back to full screen, and it's not letting me, but that's not important right now for y'all. So we have, with a couple of our partner organizations, basically developed a list of the several hundred people. It's actually probably close to 500 people in DC or from DC who are eligible and incarcerated. DC prisoners go to the Federal Bureau of Prisons, but we keep track of them. And we've created a list, and our organization, as we have capacity to take on new cases, either reaches out to people who we've done some initial screening and vetting of the client population. And so we know people who we've done some prioritization and triage of kind of what cases make sense to devote counsel to. Because right now there's still a couple hundred people who don't have lawyers. And so there's some amount of triage being done in terms of figuring out who should get a lawyer first. However, we are also available for appointment by the court. The court can also appoint lawyers, and does appoint lawyers from our CJA panel, which is essentially our panel of court-appointed lawyers who take indigent cases, indigent defense cases, as well as our public defender service. So there's several kind of sources of representation that people can draw on. How long do the cases take? I'd say the average is about a year. If someone presents just a very kind of clear-cut and strong case, sometimes lawyers will choose to move that a little bit faster. On the other hand, if there's a case that's complex in some way or has some sort of something unique about it, sometimes those can take longer. But as a general rule, I think we expect about a year for most cases.
Thank you.
Okay. Thanks, James. I'd just like to ask a couple of questions just to get this discussion going, and then I'll be turning it over to Susan to facilitate a discussion between the panelists and the task force members. Kathy actually asked the question I was going to ask James about the council, because I knew that was something your organization did. Let me ask a question then of Jane Ann. You talk about the importance of the sentencing judge being involved. In many cases, the sentencing judge is no longer around. because, you know, time passes, judges retire, judges die, judges go on to do different things. So how would that work in your view, as opposed to the actual sentencing judge having, in effect, a successor to that sentencing judge?
Right. I think courts have their own processes for reassigning a case to a newer judge. I was actually quite astonished at the federal level to see how many of the judges were still around. But we do think ultimately this has to be a judicial procedure, and we thought about the idea of categorically sending to another judge. So there's a fresh pair of eyes. And so whatever biases were at play at the original sentencing would not play at the resentencing. But we thought at the end it was appropriate to focus on, to have it go back to the original judge. It would almost be insulting not to send it back to that original judge. Where the judge isn't around, it will go to a judge in that district, probably, perhaps somebody with a lot of familiarity with the sentencing practices over time in that district who can see how things have changed. One other proposal we had was perhaps panels of judges. This is a proposal of Judge Weinstein in Brooklyn, who would, and in fact, I think maybe inspired by another judge in the Southern District of New York, but setting up panels of judges who would review the cases and discuss with the sentencing judge, so that you get more heads considering that sentence and a little more cover for the judge involved in deciding to do a resentencing.
Okay, thanks very much. And then Nazgul, the NACDL legislation talks about waiting 10 years to before someone would apply. The DC legislation in effect requires people to wait 15 years. Does any of your research shed light on 10 versus 15 versus some other waiting period for someone to be able to seek resentencing?
Sure. So in terms of research on recidivism, what we know is that after 10 years, as I mentioned, this research on criminal careers shows that most people are unlikely to continue criminally offending after 10 years of when they began. And so that's why one reason it's important to begin at the 10-year mark. Another reason is, I think, just a practical one, especially when we think about how long the process can take once it begins. And in particular, if the process is going to be going to parole boards, who are very unlikely to grant parole in the first review, then beginning the process earlier ensures that people are getting out in a timely way and at a time that's appropriate given the level of public safety risk that they're posing. And I just want to add, in terms of the DC reform that we're looking at, the cutoff here is 15 years before people can be reviewed, but there have been proposals that have been supported, including by our Attorney General in DC, to initiate the process at 10 years.
Thank you. I think, Susan, would you like to take over now and
Sure.
facilitate the discussion?
But let me open it up to the judges and to other members of the task force to see if you have any questions you'd like to direct to the panelists. For a start. Well, I want to pick up on something that was just said about initiation coming for sentencing review coming from the judiciary, because the task force legislation allows for state's attorney, the judiciary, incarcerated individual, and others to bring a motion for resentencing. I'd love to hear the panelists talk a little bit about what they think of the variety of individuals who could bring petitions. But I also want to hear the task force's thoughts about this.
I could start by responding there. So we know from the the American Law Institute, for example, has recommended that judges be the ones that review rather than parole boards. And that's partly because of the frustration that they experience with parole boards making politicized decisions. They believe that, as Jane Ann was saying, that judges, the judiciary is a little bit more politically insulated and more in a better place to really make decisions based on the reasonable public safety risk that somebody might be posing. So that's in terms of who's making the decision, but in terms of who can initiate the process, the ideal there would be for the petitioners themselves to initiate the process, and then the gatekeepers can decide, what their appropriate response would be. And I do want to add, though, that, I know from Illinois' current second look bill, which is prosecutor initiated, and some of the responses there. And we also see this in California, where if you think about the size of the state of California compared to Washington, D.C., James just mentioned that there have been about 80 releases in Washington, D.C. Well, in California, in 80 releases in D.C. where it's petitioner initiated. The state of California, which is so much larger, one of the largest states in the country, right? There's been only 100 releases there as a result of their prosecutor-initiated resentencing bill. So it really creates a serious backlog if prosecutors are the gatekeepers to initiate the process. And I don't want to overstate, though, how much judges are willing to embrace this concept, because we know that there's a lot of education that's needed, and some of the judges in California have also called for this. The need to educate the judiciary about the criminological evidence, about the legal basis for them to be able to make these decisions. So some of the research in California, for example, has shown that even when the process for resentencing is initiated by the Department of Corrections, so these are people who have the most contact with the incarcerated person that are making the recommendation that someone be released, a significant portion of those resentencing petitions are rejected by judges in that state. And so that, I think, really highlights how important it is to think about the need for education across the board in order to properly implement these reforms.
Judge Sawyer, do you have a reaction to that?
Well, I think that you however this is done, it will always be that a significant portion of the petitions are going to be denied. I think I agree that it's important that petitioners have the opportunity to initiate these proceedings, because it won't be often that the other players are going to do so. I think that it certainly makes more sense to me as well for this process to be available after 10 years, given the duration during which the likelihood of recidivism declines so precipitously. And I had something else, but I forgot. I'll bring it up in a minute.
Well, just speak up anytime.
Okay.
Could I add something here?
Oh, I'm sorry. Yeah. Please, go ahead.
Yeah, I was just going to,
Sorry.
oh, okay. So I was just gonna ask a question about petitioner-driven resentencing as it relates to court loads, especially now that we're hopefully getting toward the end of the pandemic. And so courts are now burdened even more than they were, pre-March 2020. And so has there been any discussion in the states that do have these petitioner-driven requests about whether or not there's going to be an additional burden on already overburdened and underfunded courts? And if so, how to address that?
I'm happy to share what we've seen in DC. And so that's an excellent point and an excellent question. And our relief mechanism, when it was expanded last year, made, as I mentioned earlier, several hundred more people eligible, and that really kind of is a significant number on top of the court's already kind of like present workload as a result of COVID and everything else. Our statute contemplates this possibility, and directs the court to prioritize people who have been in longer. And so it kind of recognizes the possibility that, this is not all going to happen overnight. I know that there is legislation pending that would expand or actually eliminate the age at the time of the offense requirement in DC. And I know that if that happens, there's an expectation that the implementation of the law will be phased in over a number of years. And so I don't know exactly how those kind of stages would be defined, but, such that only the broader eligible petitioner population kind of becomes actually eligible in phases, so that if the law goes into effect on January 1st, 2023, 1/3 of the eligible people are actually eligible until 2024, and then you add on a little more, so it is a concern, but also one that there are ways to address. I'll also say that our judges have developed a response to this that seems to be working. Judges handle these post-conviction matters on top of their other calendars, and though there are a lot of them, they are still being litigated and resolved, and it does not appear to be, our court system is not ground to a halt. And so, though they take a lot of time on the part of the petitioners and their lawyers and the government in some cases, our court at least has been able to make it work so far.
Can I also just add something here? Keep in mind the cost savings involved in shortening sentences when average prison costs per year per prisoner are $30,000 to $50,000. The model legislation that we've proposed would plow some of those savings back into the court system for additional personnel to assist the judges in the second look process. And certainly, as James pointed out, in the initial stages, in the initial adoption of this, you're going to have a far greater selection of people available, eligible to apply. As the years go on, it's going to be a relatively small group would be coming up each year for review. It's just the first few years, maybe the first 5 or 10 years could be really big ones. And so additional personnel can be assigned. And at the federal level, we've seen collaborative processes of committees made up of defenders, prosecutors, and probation officers that have triaged the cases, and in many cases worked out cases that everybody agrees merit a resentencing, and so save costs, litigation costs in that context.
Senator, you have a question?
Yep. I'll take the promotion.
Representative,
Actually, I'll take the demotion.
Equal. I'll say equal here.
So, when we started working on this, we were looking to do petitioner initiated, and lots and lots of freaking out ensued. But that is the vision that we hoped for. But one of the things, listening to all of this, and I was going to save this for later, but part of what I feel like we as a task force might want to figure out is a mechanism by which we look back on how what we've got is working. And whether that is getting more data from California, being able to better illustrate that contrast between what's happening in DC and what's happening in California, how the various models are working differently. And, obviously, as a task force, we are time limited, right? And our mission is defined. But, maybe part of our final recommendations involve whether, and I'm so good at giving SPAC work, but
Bring it.
is whether it needs to be statutorily done or not is a question for you guys. But giving you the how many counties are participating at all, how many cases are coming out of which counties, how many are being denied, so that we in a perfect world, which none of us live in, our law is perfect and it will work, and all of the prosecutors around the state are going to make use of it, and all of the judges are going to be on board, and people are going to get to go home. I love that fantasy planet, but we don't live on it. So, but being able to illustrate that, I think, is going to be a big part of how we expand on this legislatively. We have to be able to go back as the people who have to present this. We actually have to say why we need to do more and why this didn't work. And so, one of the things I want to put in the back of all of our heads is, do our recommendations need to include ongoing tracking and research and reporting?
Yes, always. And I would
Never
just-
ask a question you don't already know the answer to.
I would just, chime in. The DC system has been in existence for almost 6 years, and only 100 cases have been resolved. So I think Steve's point, and I think we've seen this, SPAC has seen this, when we've looked at, as Nazgul demonstrated, compassionate release type things. This is not going to be an exit ramp for a ton of people to get out of prison, which I think we all realize that. But I think what I'm hearing from the presenters, and I, throw this out, is it is one step to address the harm that that the system has now established. We've established that it's harmful to communities from a social and economic capital viewpoint, to families, and that the public safety deliverable just never materialized. And it's not just a few years of research, it is decades on that. So one of the things that Nazgul said kind of jumped out at me, and I think this is a tangential thing, but an important thing for us to keep in mind as we develop recommendations, and that is, as we have this mechanism for letting people out, we are still going to have people coming in with extreme sentences. And if that is really the issue, then we need to think through that a little bit. And there are many smaller steps along the way. And Illinois is good at taking steps. And we're particularly good at it in juvenile cases. Making mandatory enhancements discretionary is a first step. Having the juvenile parole is a step. So, we do have our mission that is defined by our legislation, but everybody at this table also brings expertise to the greater question of, are we sentencing people the way we should be sentencing people? And I'm not saying we should recommend anything drastic. I think we should just address that in whatever report we put out there.
I have one quick follow-up question for the panelists, though. I'm curious, because we know that DC was 80 out of 100 cases. With California, 100 out of how many, do we know?
I don't have that information with me, but I can look and share it with you if I can find it.
Thank you. I'd just be curious if there's a difference in proportionality.
Just to the California question, one of the issues in the differences, key differences between California and Illinois, and one of the reasons California will have fewer cases in certain mechanisms, is California had a couple of mechanisms in place. They had some parole, they had some earned discretionary credits, far more than Illinois has. So we will face a different burden coming in than a new California protocol would face, given the fact that people have had other avenues to petition for relief.
That's exactly right. California has youth offender parole hearings for young people up to age 26. They have elder parole for elderly people to get special consideration. So there are these other mechanisms. Thank you.
And retroactive consideration of the felony murder reform, which we do not have in Illinois. Thank you, Scott. You mumbled it, I shouted it. There we go.
Ari? The order was Ari.
Sorry, Senator Peters has been raising his hand every minute. I'm sorry. I feel bad because I jumped on it.
No, it's okay.
Hi, this is
So
Steve
this was
Sawyer. I'm sorry.
Oh, go ahead, Judge. No, go ahead.
I thought of what I was going to say.
I was hoping that's what you were going to say.
Well, I don't know that anyone is serious, whether we're seriously considering having the parole board make these determinations, but to the extent that they're effectively resentencing people, that would be a serious separation of powers problem. That's all.
Got it.
I don't think we're considering that.
I didn't think so.
Lisa's shaking her head.
Yeah, well, it was mentioned. It was
Considering that
mentioned.
we only have 5 members right now, that would probably be a heavy burden.
Yeah.
Throw that out there.
Oh, wow. Yes, so this is for James. I do have a question. Because I was looking at the factors, and there's 11 of them that I would say are very subjective and rather broad. And does that play a role in why you've only, taken on 100 of these cases? Is it because the fact that there must be a lot of debate on these 11 factors and the relative broadness of those factors?
I think in a sense, maybe, yeah. I mean, I think one of the strengths of our law is that it gives judges a decent amount of, or really a good amount of discretion and room to kind of use their judgment to determine whether or not someone is kind of appropriate for and deserving of a sentence reduction and release. And allowing that room for judgment kind of requires you to allow judges to, consider all these different things that are, as you pointed out, somewhat subjective and, and not so concrete. It would certainly, we would have processed many more cases, I expect, if, the criteria for determining whether or not someone gets relief were concrete things, right? If they have like a security classification score from the Bureau of Prisons and have not had, X number of disciplinary infractions in X years, that would be, make the whole process much easier. But the counterpoint is, I think that would make things, in the way that we are generally, I think, or many people are at least kind of coming to become less enamored with algorithmic risk assessment tools and actuarial tools and things that kind of try to boil a person down into kind of these easily adjustable kind of like concrete or objective factors. I think we would feel less confident in the outcome if it was really based on a limited number of kind of very concrete factors. But so that's the trade-off. I think the cases become more easily processed, but perhaps we feel less good about the methodology if, the more we kind of constrain judges' discretion.
Yeah, I'm not necessarily like passing judgment, because my follow-up is, how did you come to this 11? Like what sort of, two parts. A, what was the thinking and the base where you started from? And then what led to the 11? But what was the process that led to the 11? And sort of what is the evaluating? How do you evaluate that 11? I think is also what matters. Do you go back and you say these factors and the evolution of these factors? I mean, that to me, it's just more about 11. It's a large number with broad. It's broad. It's very subjective. And so therefore, when you have to come up with meeting those 11, what fits within those 11 factors seems like. I'm not trying to say like it just needs a perfectly done algorithm from some shady Silicon Valley tech company, but I think the balance of that, I think, is what.
No, that's an excellent point, and I mean, really, it is a valid criticism of our statute that it does not provide judges more kind of guidance and a more kind of obvious framework for how to kind of consider and apply these different factors, because it really just affords very broad discretion. And the Court of Appeals has said that it gives judges that very broad discretion. And, while on one hand that makes us feel good that we think judges are really doing a kind of thoughtful, kind of holistic review of a petitioner's case, it not only does it kind of make things less efficient, but also it creates the possibility for greater, less judicial consistency in the way these cases are resolved, because the way one judge decides to resolve these 11 factors and kind of put that together in an analytical framework can be very different from the way another judge does. And we have seen now, a decent number of cases where, someone gets granted or denied relief where it's pretty clear that another judge would have come out the other way. And that's that's the nature of judicial review to one degree or another generally, but that's part of the cost, I think. How we came up with the 11 factors, and I wasn't involved in the original kind of legislative process. They were derived largely from Miller versus Alabama and the rest of those Supreme Court cases. Why they chose to break them down into those 11, I don't know. Maybe that was the fewest they could get to. But
But they left room with number 11 because that's the equivalent to the all other duties as assigned. It's like anything else that we can think of to help us in the decision-making process, which speaks to his statement around, the decision could go one way for one judge and one way with another judge. That's just stands out for me.
James, so that I understand, is the judge presented among other things, a risk assessment?
So not as a part of the standard course. The defense petitioners' lawyers will oftentimes have a risk assessment performed, or will point to the when we have risk assessments done, they're usually sometimes they use actuarial tools, but they're kind of personalized assessments conducted by actual clinicians or psychologists. The Bureau of Prisons does a standardized risk assessment tool for everyone in their custody, and so we have that for all of our petitioners. Judges, credit that more or less depending on the judge. I mean, I think it definitely that tool has its limitations, but it's also judges are sometimes inclined to use it as kind of one data point among others. So it's not required. The more in-depth assessments are common but not standard, and there is one actuarial tool that is available as a just kind of standard part of people's institutional records.
Because I know that if I were a judge, considering one of these petitions, I'd personally feel more comfortable having an assessment to consider.
Yeah, and I think that's been certainly the response for our judges as well. And so, as lawyers, obviously, we're kind of considering the client's interest in every individual case, and maybe every client doesn't benefit from, the submission of one of those evaluations. But for the judges, I think they prefer them for the purposes of their decision making. They also cost money usually, and they're sometimes less inclined to grant them when they don't see them as strictly necessary for that reason.
Well, I wouldn't want to depend on either the prosecution or the defense to present one, because depending upon what it had, they might decide not to.
Is there any thought of limiting the number of petitions that can be filed or requiring that an attorney be appointed? Because to piggyback on what you said about the courts opening up, in Illinois, we already have post-conviction petitions, and they continue to keep filing them over and over and over again. So I think to see it work, I have a question about the fact that when they're not represented, they tend to get denied. When they are represented, they tend to get granted. And so to cut out the possibility of having a number of petitions filed, just making it a recommendation that an attorney be appointed to represent the defendants, and in the case of Illinois, a requirement that the decision be made within a certain time limit, so that to ensure that we get it over and done with, and maybe something in terms of if you are denied, you have to wait for X amount of time before you reapply, so that you don't wake up the next morning and apply again. There has to be some tighter controls, I think, at least for Illinois.
I think I saw in one of the, I can't remember which example, but it did say you can't reapply for 3 years or something.
Yeah,
is that DC or California? It's DC.
That's how DC's works, and it was You get 3 reapplications, and after that, you're done.
So you have to wait 3 years, and then you can only do it 3 times in your lifetime.
That's right.
Okay.
Okay, yeah, we definitely,
One thing I just wanted to note is that some of the, in terms of workload concerns, some of the post-conviction petitions that you were referencing would then get transferred over to these resentencing petitions. So in some ways, it can, you know, just reclassify and reorganize the work that's already happening.
but it's a separate issue though.
But it'd be easier to get relief,
Yeah,
don't
maybe
have
it'd
to-
be easier to get relief, yeah,
Yeah.
true.
more expedited.
And anecdotally, from a client's perspective, the tool available right now is the post-conviction petition. The only thing they've got, or a
Yeah.
214-01, but they basically have a PC, and so they're going to cram whatever you can into that.
Okay.
Frame your argument as a constitutional violation, but but what they're praying at home or in their cell is like, I want a time cut. I would like my sentence to be reduced. And so if a different path were made forward, I would
Yes.
have to believe our PC docket would go way down while we work through the sentencing docket.
Just to chime in on that point slightly, I mean, the Post-Conviction Hearing Act is sometimes not a great fit for what the person wants to do for this, right?
It's their only fit.
But it's the only fit they have, so they're trying to shoehorn into a constitutional claim, which may or may not work. So, you know, perhaps there'll be some burden relieving on that side, and I completely agree that, you know, oftentimes the uncounseled pro se petitions, you end up, it's just kind of a mess, you know, for that person who doesn't have the resources, of course, to present it, and maybe have, you know, issues in terms of mental health or, you know, everything else that might be true for them versus a counseled one. That's true.
Do any of the panelists have experience with that? Have states seen a drop in other forms of petitions for relief?
I think probably yes. You know, and the nature for anyone who's kind of represented, in DC at least, who has represented or presided over, you know, cases in which people have been incarcerated for a very long time and are going to be incarcerated for much longer, is that people tend to get litigious and file pretty much as many post-conviction, some people, not all, but a lot of people will become very kind of prone to filing post-conviction claims, a lot of which are not meritorious, but they see it as their only shot at getting out someday, and so that's what they do. Now that we've afforded people an actually kind of meaningful opportunity, I'd say we're absolutely seeing a lot less of those kind of otherwise frivolous post-conviction motions being filed.
So
Oh yeah, so I was gonna go back a bit to both what Kathy and Nazgul were saying about how this isn't, you know, an off-ramp for everyone to ultimately get released from these long sentences. And so my question is kind of broader in terms of where do we go from here? So 57% of the IDOC population as of the end of last year was serving sentences for either murders or Class X offenses. And so if, let's say, you know, petitioners are able to file their own petitions for resentencing, in an ideal world, you get rid of this 57%, and in an ideal world, the arc of the moral universe will bend towards this liberatory form of justice. But we already know that we don't live in an ideal world. We live in the best of all possible worlds, according to Voltaire. And so where do we go from here? Should not the issue also be what tweaks need to be made to our current sentencing laws to ensure that we don't go back to the peak of 40,000+ people incarcerated in 2013 or 14 or whatever year that was? So should it not be a broader call for, I don't know, an end to truth in sentencing laws, or a return to discretionary parole, or some iteration of those things, so that if, again, you do have this petitioner-initiated resentencing or prosecutor-initiated resentencing, it becomes more obsolete as time goes on?
Thoughts? I mean, I'm hearing an expansion of sentencing review as not even just individual sentences, but you're talking about the mix of sentences.
And I think the bite that you talked about, Illinois is good at steps. The step we're in right now is dealing in many ways with the harm done of the past. And so part of the genesis of this effort, I believe, was that we had, as a state, kind of adopted some new norms about prospective sentencing. So that, you know, you've seen the examples in recent years legislatively. None of them went back. So we ended up with this really scary moment where a lot of people were going to be getting a different type of evaluation, different type of sentence based on the year they were sentenced, right? If it was wrong on Wednesday,
Tuesday
it was
guy,
wrong on
Wednesday
Tuesday,
guy.
right? So one of the things that I think, and I'm gonna, so I don't have an answer to your question. I completely agree with you philosophically. I would argue that politically, the state of Illinois in this moment is, you know, if we open that can of worms right now, we may not get to deal with the knot of people who are stuck. But I will redirect it as a question, because this is a question that's been on my mind. So I'd like, particularly Nazgul, who's looked at some of maybe a broader array of states who have different types of relief. Again, we're calling it resentencing task force because that's the mechanism that we think has the best chance right now of providing some relief. But in many states, whatever your post-conviction, post-sentencing relief, meaningful review, parole, judicial resentencing, whatever you choose, has to have some relationship to the mandatory minimum sentence structure. And have you seen instances where the mandatory minimum structure was above your 10 or 15 year mark and that the minimum itself had to be adjusted, or you know, as I think has been discussed in previous legislative efforts that we've been a part of, folks have said, fine, we can talk about this all you want, but we're not going below 20 because that's our mandatory minimum, and the new statute will not be able to crack that nut.
Right.
So in other words, the mandatory minimum would stand no matter what the other, the new statute asks for.
I mean, I will defer to some of the other attorneys here to advise on that, but in my experience, these kinds of resentencings in many jurisdictions, like in Washington, D.C., are able to handle people that have a life without parole sentence, for example. And so they're able to cut into that and let them out earlier than would have been imagined at the time of sentencing. And before others chime in response to the question, I just want to just say a quick thing in response to the previous point about getting, you know, shouldn't there be some focus on front end sentencing reform as well? And in terms of, you know, there's issues of whether or not that's politically viable, but I did want to underscore James's point that, you know, right now we don't have anyone with us, I think, that has been that's able to speak to the experience of going through this resentencing process themselves, right? And in Washington, D.C., what we've seen is, and we can see this more broadly in other jurisdictions as well, is that when people are released as a result of these back-end sentencing reforms, they can become very effective in advocating for reconsidering sentences at the front end. And that's partly because so much time has gone by since their original offense, and people are able to better imagine the possibility of reform and rehabilitation when they look at them, rather than when they look at someone going in at the age of 19 or 20 for a very serious crime. So just wanted to add that and then pass it on to others on the question of mandatory minimums and resentencing.
And we do actually have a commissioner who is part of that community of people making that case, Jacob Delaney.
Kathy, I think we need another criminal justice and sentencing reform commission. So that I can argue again that we need defendant-based sentencing, and we need to have assessments before every felony sentencing, even.
I should say that Steve served, as did I, on Governor Rauner's Commission on Resentencing and Criminal Justice Reform, which met for 2 years and issued, I don't know how many recommendations to the credit of our legislative colleagues. There were bills that implemented several of those things, and to the credit of people on that commission, we uttered the words truth in sentencing and is it fair and should we revisit it? But fortunately that did not make it to the recommendations. So
I want to interject here just to say we have a couple minutes before the public comment period opens up. So if you have a burning question for the panelists, now would be the time to ask it. It doesn't have to be burning, but go ahead.
I'm not to burning. I'm not sure. I was intrigued by like the low simmer. No, I was intrigued by your some of the comments about not having a carve out, which I think is. I mean, I agree with you that that's critical. And once again, kind of related to a previous point, to the point just made. I think that tends to be more of a political question rather than a thoughtful, evidence-based question when it's posed. I think most people who actually study the stuff know that, rehabilitation isn't crime or offense dependent. It's, it's a growth process for an individual. And so I was wondering for the panelists, was there feedback that we could sort of incorporate or think about in terms of pushback to that notion of carve-outs versus not? Anything you think would be helpful from other states?
Other questions or comments?
Well, do panelists have any thoughts on
answers?
that?
I mean, I'll just say it's a tough political question, and it really is a political one. And what we've seen in other jurisdictions that have tried to are trying to pass similar reforms, the political pressure to create these carve-outs or exclusions is really, really great. As advocates and people who kind of work with this client population, I and the people I work with are really convinced that they're bad policy, that they, exclude a lot of people who are really deserving, kind of as contemplated by the spirit of laws like these, and it kind of misses the point to make those carve outs. And I think there is a humanitarian cost associated with that, but also you want to get something passed, and or maybe you do, maybe you don't. People generally do, and that's that's.
Yeah.
That's hard. I mean, like the pressure is going to be there. It almost always is. We were able to avoid that here in DC, but it's something to contend with. And I think probably the best way of kind of countering that pressure is to come up with compelling stories find real people who would be excluded by those provisions, who can even convince a hard-hearted person that, like, okay, well, this is clearly someone who deserves a second chance. So maybe it doesn't make sense to cut people out.
Your hand up.
Could I just add something on that? First of all, if you have carve-outs, you're going to end up having litigation about whether the carve-out applies, possibly. But also the carve-outs really, take away hope from the population in prison and from their families and their communities. And part of the goal, I think, in a second look statute is to, bring some of those very alienated communities back into the fold. And so carve-outs, I think, really will disappoint those communities and increase the alienation. And I don't think it's necessary, because in those extreme cases where people feel second look shouldn't be applied, the judge can do that in an individualized basis. And it can also be assisted through a committee process with probation officers, prosecutors, and defense lawyers to streamline things a little. And so I think that more expansive is probably ultimately going to achieve the greater goal of reintroducing humanity into sentencing.
Thank you. So I have a question. There was mention of the savings that comes from resentencing and reducing the population of the Department of Corrections. But is there any research or studies regarding those savings compared to the social cost of crime, and having victims of these crimes have to relive the crime after, let's say, 10 years, when they're going to have to come back and testify at a resentencing hearing? And is there any studies or research regarding those defendants that are released early, the cost to society for the percentage that does reoffend?
That's a great question. The research that has been done on cost of incarceration, it considers the cost of crime and considers the research that I mentioned, which is that the population that would be released after serving lengthy sentences is extremely unlikely to recidivate. And so when the kinds of costs that we're talking about to incarcerate people in their 50s and beyond gets extremely high, so much higher than for the younger population, because when someone who's incarcerated and is elderly and needs serious medical care, it's not just the same level of care and cost associated as if they were on the outside. If they need to get care at a hospital, they're accompanied by several guards. And so that's how the cost of incarceration really dramatically goes up. And, just to add a little bit of nuance to that, one tricky thing about calculating savings with respect to when that population is released is that we've seen in a number of states now around the country, as crime rates have come down, some of the states that have experienced the biggest crime drops are also the ones that have reduced their prison populations the most. And yet they have not these projected savings have not materialized. And that's because of the significant overhead cost of running these facilities. And so unless a particular wing or entire prison is able to be shut down, you cannot get the savings just from releasing individuals. You need to be able to release enough so that you can close wings or entire facilities. But with respect to the cost of crime and people released committing reoffending, again, I think there's a lot of assurance that's provided there by the research that this is a population that's extremely unlikely to recidivate. And so we can point to, like James was saying, 3 arrests out of 80 releases. We can find instances where people do criminally reoffend, but those cases are the ones that are the exceptions and in terms of financially, if we're just looking at it in terms of cost benefit, there's much more benefit to be had from releasing the larger population and reinvesting those savings more effectively to prevent victimization, rather than continuing to incarcerate those people to prevent that small rate of recidivism. There are much better investments that we can make to prevent those kinds of crimes and similar crimes from happening.
And can I say something to that too? For anyone who is interested, IDOC publishes the cost of incarceration per inmate per fiscal year publicly on their website. And so you can see there's a variety of costs. So some facilities are as low as $30-something thousand, which is not really low. But Stateville, for instance, which is closest to Chicago, is about $52,000 per inmate per year as of FY20. And Joliet, for the seriously mentally ill incarcerees, was, I believe, $177,000 per inmate for 485 people during FY20. And so I think that's where these costs come from, and the concern about those fiscal costs.
But I will say, Bob, you know this because you're the guy who put this on SPAC's plate. We do calculate victimization costs, and we can track that, and we can talk about recidivism costs, and it really depends on the type of crime that's been committed. So when you look at the recidivism rates in Illinois, we can certainly put together some numbers. But I will also say I'm a fan of good risk assessment tools. And what the risk assessment research has shown over the years is that people who commit violent crimes are among the least likely to recidivate because their crimes were usually crimes of passion. And they stay in prison for a long time, age out. Public comment, we are up to that point, so I'm sorry everybody else, you're cut off. But I'm gonna let Bob respond if he wants to, because if you have a response to the answers, I don't want to cut you off, Bob.
No, thanks. Thank you.
Okay. Public comment, I see a couple of phone numbers online. And I'm gonna ask John Specker if he has any emailed questions or comments. John?
I do not have any emails right now.
No emails right now? All right.
Nope, and I've not gotten any throughout the session.
All right. I don't think people who are calling in can actually speak and be heard. So if any of you have questions or comments here at the conclusion, please email john.specker@illinois.gov. And I don't think we have anybody in the room. We do not from the public. So, I think we have no public comments.
Yeah, so we just got a couple more minutes and I thought, why don't we just go around and say what our key takeaways were instead of me summarizing what they are. I'd love to hear what you guys have to say. So Joby, do you want to start? Can I put you on the spot?
Absolutely. I like that strategy of closing the meeting. Thank you for doing that, because it might give folks who haven't had a chance to speak a chance to speak. Since I have had a chance to speak, I'll be really brief. I appreciated the idea of creating sort of a shared sense of what we're aspiring to, and what I'm taking away from this meeting is a real desire to, as Representative Cassidy said, look, we can't compare ourselves apples to apples with other states. What we can do is look at where Illinois sits compared to states that have other release mechanisms, and what it would take to get Illinois even to par with those other states. What would it take in a set of resentencing proposals just to get us to par with the majority of the states in the nation that sort of have come to recognize, or have always recognized, that this is something our criminal legal system needs in order to function fairly and safely.
Scott?
I want to thank Judge Ingram for joining us, for being part of the task force, and Judge Sawyer. I think those were definitely missing ingredients to our first meeting, and so I'm very grateful to have your perspective and wisdom brought to our conversation. And sort of thinking about that and thinking about the 11 factors that DC outlined, factor 10 really jumped out at me off the screen, because I think that was focused on some of these are going to be really difficult, awful offenses, but that doesn't stop the conversation. So I think that that was the one thing I was going to ask James to put that back up, because I didn't want to do the research myself, but I can do the research. But I guess this will be a flip way to conclude, but 11 would be a luxury for our judges, because we currently ask them to think of 30-some things, like our factors in mitigation and aggravation. That's two long statutes that are always required to be considered, and no one's trying to stop that conversation. No one's trying to eliminate relevant information to be thought of. But I think what DC, the work they have done is sort of to try to distill it down to what should we really be thinking about now, 10 years later, 15 years later. And so I think I'm excited that we're starting to sort of roll up our sleeves on that question.
So
I don't have a lot to add. I was just going to say that I just want to express gratitude to the panelists and the new members of our task force, because I do think we need these perspectives between survivor and victim family perspective and our judges too. And in terms of, I want us to just, I think, be mindful of the fact that these burdens, what we've done in Illinois is such a mishmash, honestly, from the petitioner's perspective, from the judge's perspective, even from an attorney's perspective, that I really look forward to us being comprehensive and thoughtful, and maybe even in an ideal world sort of streamlining a little bit so that everyone kind of knows what to expect, because I think it's clear we have a big problem, and that it's not being addressed, and not addressed fairly or sufficiently from anyone's perspective. So I'm grateful that we're gonna, start to dig in and do this work, and thank you to the panelists for really giving us these global perspectives, because sometimes when you sit in one state, you sit in kind of an island, and so it's nice to hear that national perspective.
Judge Ingram?
Yeah, I think it's good to see, an alternative to the unnecessarily long prison sentences that have been given over the years, and the fact that after 10 years, based on the information that we have, it shows that there's a reduction in the likelihood of recidivism is something I think that will really help the judges with that, knowing that, to at least buy into a new process.
Thank you. Kathy?
Go to the members first and then come back to me.
Senator Peters?
Yeah, I think for me, anytime, especially with the presentations, anytime we have these conversations, is that I feel that there is a constant sense of tension and contradictions that inevitably, this is not the most politically correct way, cripple the progress towards actually establishing safety, and that oftentimes people either try to ignore these tensions and contradictions, or they try to resolve them by creating more tensions and contradictions. And that it might be best to actually sit in the tension and contradictions to then figure that out. And what I mean by that is to go back to the first presentation that really got me was the fact that when it came to violence, people were still being incarcerated even though violence was going down, which means that inherently there was a contradiction that existed there, and that it seems like that's something we have in front-end pressures, and we're talking about back-end pressures, and talking about an overloaded system and worrying about overloading the system, and you actually have right in the first slide of the whole thing the answer to that issue at the same time. And so to me, as we're going through this, and I understand it's about resentencing, the broader issue still exists within the contradictions and tensions, that if we don't actually do enough to resolve that, we're just spinning our wheels.
Cool.
For me, having carried this for several years in various forms, our law was a big give on my part. It was a major compromise because of the sort of fundamental desire to have a petitioner-driven process, and I have some hope because Illinois doesn't like to be first. We know this, right? We like a couple of lemmings to go off the cliff is what we do. And so I'm encouraged by having, some places to look and watch, and feeling a little more hopeful, because not a week goes by that I don't hear from at least a couple of families or inmates who are who have absorbed this as a petitioner-driven process. They believe that our law is petitioner-driven, and they want to know what to do. And every time I'm engaging with either the inmate or the family, I am holding my breath when I ask the question, what county were you sentenced in? I spend a lot of time tensed up and holding my breath, whether they're going to have hope or not. So I'm just encouraged by our desire to keep moving through these tensions and contradictions, as Robert put them. So I just want to thank everyone for bringing all of this to the table.
Yeah, so I echo the thanks to our panelists and our new members, and I'm just really grateful that today's meeting included data and statistics around the lack of utility around longer sentences, because sometimes I think we get really lost in the anecdotal stories of the worst case scenario when we need to treat those as outliers instead of examples.
Lisa?
I don't have a lot. I just want to say thank you for inviting me to the space from the perspective that I sit. Although as a survivor of violent crime, although as a member of the Prisoner Review Board, I am no stranger here lately to tensions and contradictions. However, one of the things that I am humbly taken away from this conversation, and I'm sure those that will follow, is first and foremost is also to the Senator's point, that we are coming to the space with an open mind and a willingness to be uncomfortable. to get settled in the discomfort. These are hard conversations that need to be had, that are long overdue. And everybody in the room that's in the room is gonna find themselves uncomfortable in their seats at some point or another. And I'm also appreciative of the opportunity to exemplify that there is capacity to hold space for the survivor of violent crime as well as the person who has committed a violent crime, and hold space for the humanity of both and speak to that even in the hard places. So I'm grateful for that.
Thank you. I'm gonna go to the folks online, and some of you, just so you know, all I see are your phone numbers, and so once I get through everybody's name that I can see, I'm just gonna ask that you self-identify and give a share. Bob Berlin.
Right here.
Yeah, do you wanna share a takeaway from today?
I appreciate the thorough, robust discussion.
Very good.
Chuck Sawyer.
Well, so do I. No, I think that these are important perspective measures. I do believe that in order for this sort of a process to be effective, it is going to have to include the use of assessment tools for consideration by judges. I also think that the judges are going to have to be required to make written findings. And there are some intangible negative effects to such a process, which have been brought up or alluded to. And so it's beyond our purview, but it seems to me that it may be necessary for the legislature perhaps to differentiate as between types of offenses in the application of the program.
Yeah, Cole?
Yes, thank you. First, I want to thank the panelists as well for providing all of your experience and giving us here in Illinois an example of what we can do with resentencing. I like sitting here. I have a lot of notes, but just want to highlight a couple of things that really stood out for me, like the importance of enabling crime survivors in this process of resentencing, and also the importance of legal counsel for the applicants that will be applying for resentencing. Just as a person who've experienced an extended sentence, and as a person who have worked in a prisoner voluntary and eligible applicants who are not capable of filing meritorious petitions. And so I'm just, those are some key takeaways that I'm thinking about as we've been having this discussion, and definitely want to make sure that we lift those up as we continue to move forward.
Thank you. So, folks who are members of the task force who have not yet shared, would you like to do that? I can't really call on you because I don't see your name.
I think we have everybody.
So we get everybody? Okay.
Latoya was the only one, she left the call.
And Representative Spain might have left as well.
Yeah, I think so.
Okay.
So we've had everybody.
Well, then I turn it over to Susan for some
And I want to
closing
echo
comments.
the thanks to the panelists. Everyone here has acknowledged the quality. I have to say, this is a messy human endeavor, right? And so I actually am a little nervous because you've now raised the bar for every other panel over the course of this initiative. So thank you so much. I do want to ask everyone here to mark their calendar for the next meeting, which is June 10th. That is the next panel, looking at issues of behavioral health. We're also going to introduce at that point a set of guiding principles
for consideration. We won't act on them at that meeting, we'll wait to the subsequent meeting so that there's plenty of time for people to have a conversation about the principles that should guide this work. While you're at it, looking at the calendar, please check the rest of the dates, and if there is a date that's gonna be problematic for you, please let us know so that if there's, a date that's gonna be a misery for everyone, we can make.
And those are in our last email? Those upcoming dates?
Yes, just send that to Kathy.
It's in the last email, that's what I asked, because I don't remember seeing it either, but I have to go back and look.
The calendar?
Yeah.
It's in the packet.
Okay.
But we can send it out again. And then I guess I just want to ask everyone here to join me in wishing a happy hippie experience. Our colleague here, Kathy.
Can't wait.
And as the newbie in the room, I want to thank everyone here for the very thoughtful contributions today. In addition to the panelists, it's been a very rich discussion around the room. Thank you.
Thank you.
I do need